Mr. Mayor, members of the council, thank you for inviting me here today. I have a pretty brief presentation for you on the open meeting law. I'm sure that you are already quite familiar with it, but I wanted to go through a few things today, focus in on some stuff regarding communications among council members and other members of other public bodies that I hope will be useful to you. So with that, we will dive right in. First off, I think it's important to always
I don't want to interrupt you, but make sure everybody can see that you're in a position that you can see the audience. If you want to move down, there's a screen in the back if you're more comfortable, but please get in a position where you can see.
And also, we made additional handouts that have the information that's in the PowerPoint, and I'm sure if there aren't enough copies, more could be made.
And it's also going to be posted on the town's website.
Great. All right, so starting off, I think it's helpful to look at what the purpose of the open meetings law is. And the purpose that's set forth in the law itself is that it's the state's public policy that meetings of public bodies be conducted openly, and that notices and agendas be provided for such meetings which contain information that's reasonably necessary to inform the public of the matters to be discussed or decided. And underpinning this purpose is that any uncertainty when it comes to the interpretation of the open meetings law should always be resolved in favor of openness. So if that's really the guiding principle. Really briefly, just some technical stuff. The sources of the open meetings law, it's in the Arizona Revised Statutes, Title 38, 431, and subsequent sections. The source of really the best information, which should be very useful to you anytime you have a question, is the Arizona Agency Handbook, Chapter 7. It's all about the open meetings law. It's drafted by the Attorney General's office. It's revised on a regular basis. There's a link there to it so you can get it online. And that answers a lot of questions that you wouldn't be able to find the answers from just by reading the statute. And then there have been cases interpreting the law as well as Attorney General opinions. And that's actually a lot of what we'll be talking about a bit later in the presentation regarding communications comes from an Attorney General opinion. All right. This is all probably sort of a bit remedial to those of you who have been serving on a public body, but it applies to, the open meeting law applies to public bodies. And there's a sort of long definition. Most applicable to you is that multi-member governing bodies of political subdivisions of the state, including counties, cities, and towns, as well as school districts and special taxing districts, those are public bodies. But also included in the application of the open meetings law are advisory committees. If you were to appoint an advisory committee to study and report to you on a particular matter, and also special and standing committees created by public bodies. They're all subject to the open meetings law. All right, just the basic requirements. All meetings of a public body, much like this one, shall be public, and all persons desiring to attend shall be permitted to attend and listen to the deliberations and proceedings. And any legal action of a public body must occur during a public meeting. So that raises a question. What exactly is a meeting? This is very clearly a public meeting, but there are other things as well. So it's a gathering in person or through technological devices of a quorum of members of a public body at which they discuss, propose, or take legal action, including any deliberations by a quorum with respect to such action. I'll go into greater detail as to what legal action is in a moment. But it's important to note that it doesn't matter what label is placed on the gathering. This is a sort of the classic example of a public meeting, but you could have a work session or a study session. A quorum of the public body could find themselves together at a social function. If that happens and you discuss matters related to the work that the public body does, that constitutes a meeting, and if not properly noticed and with an agenda, then that is a violation of the open meeting law. But also, and we will definitely get into greater detail on this as the presentation proceeds, it can include communications among a majority of members via email, text message, or on a social media platform. Now, legal action. This is the definition that comes from the statute. All discussions, deliberations, considerations, or consultations among a majority of the members of a public body regarding matters that may foreseeably require final action or a final decision of the governing body constitute legal action. Unfortunately, that isn't the clearest thing in the world. You sort of have words that show up in both parts of the definition that aren't defined, and then so you have the definition of meeting, which is where a quorum discusses, proposes, or takes legal action, including any deliberations about that legal action. But then the definition of legal action includes the same types of conduct regarding these undefined terms, final action and final decision. And in true lawyer fashion, I'm afraid I'm not going to clear it up for you very much. But just sort of, I think the main thing to keep in mind is that it's very broad. And just about anything you do that has to do with the business of the town could very well constitute legal action. And so you need to be careful about when and with whom you're having discussions about it. All right, agendas. In order to have a public meeting, the public body has to limit discussions, consideration, or decisions, that is legal action, to matters that are listed on the agenda and other matters that are related thereto. Because the purpose here is sort of giving notice to the public, the question of whether a matter is related to an agenda item needs to be construed narrowly. So sort of it has to be pretty closely tied to the agenda item. An agenda has to contain a listing of the specific matters to be discussed, considered, or decided at the meeting, as well as the time and place of the meeting. If there is to be an executive session, it needs to be noted on the agenda of the open meeting, and executive sessions must also have their own agendas. And they have to specifically identify the reason for the executive session. There are several subsections of ARS 431.03 that permit executive session, and you need to identify specifically which one of those subsections permits the executive session. Oftentimes it's going to be for consultation with your attorneys, could be to discuss personnel matters, contract negotiations. Those are some of the things that can properly be discussed in executive session. Importantly, public body cannot take legal action in an executive session. You have to adjourn the executive session and return to the public meeting to take the final action on an executive session issue. Calls to the public. This can create creates difficulty for some public bodies. I don't know if you've had what type of experience you've had here, but they are permitted but not required. The open meetings law doesn't give the public a right to participate in the public meeting, but a public body may give members of the public the opportunity to address the body. But even if you do that, you have to make sure that you don't discuss or take action on something that is raised during the call to the public that's not on the agenda. But on the other side, members are permitted to respond to criticism by those who've spoken during a call to the public, ask staff to review a matter, or ask that a matter be placed on a future agenda. So you don't have to completely remain silent. Here's the part where I'm supposed to scare you. The penalties for violations of the open meetings law. If action is taken in violation of the open meetings law, in a meeting that wasn't properly noticed or the like, the action can be voided or nullified. But more importantly, individual members of the public body who violate the open meetings law can be assessed a civil penalty of $500 per violation, and that civil penalty goes directly to the member of the public body. It's not paid by the public body. The public body is not allowed to pay it. If it's a matter that ends up going through litigation, attorney's fees can be assessed against the public body, but the individual person who violated the open meetings law could actually be required to pay those fees, him or herself, if he or she acted with intent to deprive the public of information. And if paying attorney's fees isn't bad enough, you can be removed from office for acting with intent to deprive the public of information. All right. Now, this is really the sort of the meat of the presentation here tonight. I'm starting off with a sort of, want to help you conceptualize this. So the way the open meetings law is written, there are 4 activities that can only be conducted at a properly noticed public meeting. So that's proposing legal action, discussing legal action, deliberating with respect to legal action, and taking legal action. So 3 of these, discussing, deliberating, and taking legal action, require two-way communication, basically an exchange between members of the public body. In order to discuss, there has to be some back and forth. But proposing legal action is different. It can just sort of be put out there. One person can propose something and if it's received by a quorum of the public body, then and it happens outside of a properly noticed public meeting, then you have a potential violation. So you want to be particularly careful with communications that propose legal action. And what I now have with that background are a number of different examples that I think should be helpful to you. And the reason that we have all these here is that I'm, especially with the way we communicate today through text messages and emails, over social media, there are a lot more opportunities to violate the law. So I want to give you a pretty firm understanding of what you can and can't do. So we'll start off with the bad stuff, things that violate the open meetings law. Email discussions between less than a quorum of the public body's members that are forwarded to enough other members that a quorum sort of sees the whole discussion. And if they're forwarded by a member or at the direction of a member. So, the mayor and the vice mayor have just an email back and forth about a matter that's on the agenda next week, and then the vice mayor forwards that to the rest of the members of the council. Then you're going to have a problem. That would be a violation. Here's another example, this is really sort of pretty similar. You have one member who emails 2 other members about a particular subject within the scope of the public body's responsibilities, and he's already had a conversation with the other 2 members and tells the ones to whom he sends the email what the other 2 have said. Basically, that's sort of an improper, what we call serial communications. And you end up with a quorum seeing that, and that is a violation. A couple more violations. Oftentimes, because this is so difficult, there's a desire to communicate through staff to prevent violations, but even that can be a little bit dangerous. So if you have a staff member who meets individually with each member of the council regarding official business, but then that staff member shares the comments made by other members with a majority of the members of the council, basically you're facilitating discussion or deliberation. The staff member is doing that, and that's a violation. And then finally, discussions or deliberations in person or through over the phone, through email, on Twitter, between less than a majority of the public body can violate the open meetings law when they're used to circumvent the purposes, to do something not in the public eye. So this is called splintering the quorum, basically talking to someone over here and then talking to someone over there, having serial discussions that lead to eventually a quorum becoming aware of these discussions, but having it happen outside the public eye. All right, now we have some things that are a little, they're squishier. They could be okay, they could not be okay. So the first example would be an email from staff to a quorum of the members. Starting there, that's fine. That's not going to violate the open meetings law. But if the members of the council reply to the staff member, they can do that as well, but don't copy the other members of the council. If you send it to, if you hit reply all, then you're going to end up basically having a discussion that's improper. And here's another example. So if you have a smaller group, an advisory council, so you have a 3-member public body, one member can email a communication to another member. So two members of a 3-member public body are a quorum. You could still send an email to your colleague, setting forth your facts or opinions relating to the public body's business. But if the recipient of that email responds, then that's a discussion. And that would be a violation because you have 2 members and that's a quorum. Okay, here's another example. If a member of the council were to send a request by email to staff for specific information about a matter that's coming before the council, it's okay, even if other members are copied on the email. But the staff member can reply all, as long as that response does not communicate the opinions of the other members. But the other members shouldn't reply in a communication that includes enough members to have a quorum. That becomes a discussion or deliberation. All right, and then here's another one. And I would imagine in a community of this size, you're quite often out there meeting with your constituents and having the opportunity to discuss issues important to the town outside of a public meeting. And I don't know if the town has a Facebook page or a Twitter account, but if you do, that's another place where I'm sure you're interacting with your constituents. And also through, traditional media outlets, newspaper, television stations. So a member of the public body can voice an opinion, discuss an issue with the public through all of those means, as long as the opinion or discussion is not principally directed at or directly given to another member of the public body. And there's no sort of plan to deliberate outside of a public meeting. No using the Twitter feed to get around the open meetings requirement. All right, and now because I wanted to be nice and end on an up note, here are some things that you can do without violating the open meetings law. If a staff member or member of the public emails a quorum of the members of the public body, and there are no further emails among the members, there's no violation. That's perfectly fine. A member of the council can email staff and a quorum of the members proposing that a matter be placed on a future agenda. and this comes sort of straight from the Attorney General opinion. It says, proposing that the public body have the opportunity to consider a subject at a future public meeting without more does not propose legal action, and therefore it wouldn't violate the open meetings law. So you could say, I think we should talk about this in the future, but I would recommend against saying, I think we should decide this issue in this fashion in the future. And here's a couple more. You can copy other members on an email response to a constituent inquiry without violating the open meetings law, because that's a sort of unilateral communication. It's not discussion with the other members of the council, and it's not taking legal action. And then finally, you can use email to send an article, report, or other factual information to the other members of the council or to a staff member with a request that that document or similar be included in the agenda packet. And staff can also distribute agenda packets to members via email. And that is all. I hope that was helpful.
Before we let you go,
yes.
Does any member of council or the commissions or the audience have a specific question that they would like to ask? Must have been a lot plainer than when I first heard the open meeting laws described. Yes.
Sorry, I didn't push my button, but is it?
Sure.
I did have a couple of questions, if I might. First, on slide number 6, you mentioned discuss matters related to, and it's not on the slide, but that was, I tried to write down quickly. I've always had a little trouble personally deciding where that line is between what we're actually going to act on and what are matters related to that. And so my personal kind of modus operandi is to say, if it even sounds like it might be a pig, let's just treat it like a pig and avoid the issue. Is that probably the safest?
Absolutely. I think, I think what I've said was that, sort of starting from the first principle of openness, that related to needs to be construed narrowly, sort of you define it very narrowly. It has to be very obviously related. So if you have any concern about it that it's not closely enough related to an agenda item, then, suggest that it be placed on a future agenda.
Okay, thank you. Second question then. Can you help me understand what is meant by the term ex parte communication? And is that really playing into this, or is that?
Well, I mean, legally, ex parte communication would be communication by one party with a judge. Like if you're in litigation, one party speaking to the judge without the other party present. So I think. Sort of.
Where that comes in is we often have applicants approach us and talk to us about a land use case, for example, and I speak for all the council when we say most of us are open and willing to meet with applicants to try to get a feel for what is their issue, but I try to be very careful about not telling them how I would act on the matter. I'm willing to listen to their spiel, if you will, and in general terms will express concerns or questions I have, but never tell them how I'm going to vote. Try not to be, so I just want to make sure that I'm treating that correctly.
Well, I think there are probably some issues here that relate to the application process and that are maybe outside my expertise. But you are certainly permitted to individually do fact gathering, and that is, it sounds to me that that's sort of what this conversation is.
The other part of that is that sometimes applicants want to tell me how other council members are planning
Yeah, and I would,
to act. And that's where I always try
right,
to
I would
stop
suggest
and
that you
say,
caution them against doing so.
Okay. Which brings me to the final question, which was, you mentioned on, if I get this right, page 5, the top slide, the situation where the staff member inadvertently acts in a way that communicates what other committee or board members are thinking or how they're likely to vote. Who is at risk in that instance? Is it the person who said what
The
they were
staff
going to
member
do?
is at risk.
It's the
You
staff.
don't have to be a member of the public body to be subject to being found in violation of.
And then the final question is, because I love my friends on committees and boards, and we usually run into each other at the grocery store, and sometimes we get to talking, and that's where I'm always really afraid. You know, I even sit on some of those committees. So
Yeah, I
in
mean-
those instances, we want to be really extra careful not to.
You do want to be careful. It's, the big concern is when it's a quorum that's having these sort of informal conversations that bleed into talking about the public business. If it's, you yourself are, especially if you're not on that committee, and you have a conversation with someone on that committee about the committee's business, you're not, you don't have a quorum, you're not sort of in a meeting. But again, being careful is the best way to go. It's sometimes it's a little bit difficult. This is something you have in common. This is something you're interested in. It just comes up in conversation, and it can sometimes, I think, feel a little stilted to be like, no, we can't talk about this. But that's the safest way to go.
Okay, thank you.